Good morning. This is Jerry Tuttle, and I'd like to talk about copyright and math teaching. So let's start with these two cartoons. In the first one, that's supposed to be me in a car being pulled over by policemen for speeding at 70.001 miles per hour in a 70 mile per hour zone. So obviously the chances of being pulled over for that and being given a ticket and convicted is pretty small, but that really is against the law. In the second cartoon, that's supposed to be me photocopying lots and lots of copyrighted documents, and that's also against the law. So in each of these, the chances of getting caught are pretty small. In the copyright instance, the copyright police does not magically descend just because there's a copyright violation. But as teachers, we should set a good example to our students in obeying the law and understanding copyright. So let's do a few copyright examples. May I play an audio clip in class? Here's clip one.
Pretty woman walking down the street, pretty woman. Pretty woman, girl, you look so sweet. Pretty woman.
Okay, that was clip one and clip two. Clip one, the older people in the audience probably recognize that as Roy Orbison, Pretty Woman. Clip two, you may not recognize. That's a rap group, Two Live Crew, singing an R-rated version of Pretty Woman. So first, may I play these audio clips in class? Yes. The Federal Copyright Act and subsequent court decisions are authorities. Yes, I may play these based on Section 110 of the copyright law and a Supreme Court decision on Pretty Woman. But I think the more interesting question is not only may I play these in class, but how is that second group able to make that R-rated rap version? And we'll talk about that. So here is a graph. Can I copy and distribute this graph? Yes. First, it's based on federal information, which has no copyright. Moreover, the graph is based on facts and data, which have no copyright. And I drew the graph, so it is my creative contribution. How about copying and distributing from a book? This requires a fair use analysis and probably fails fair use factor number 4. It's probably okay if done in a small amount. You can't copy to avoid buying the book, and you can't copy to a consumable worksheet. How about a journal article? This is my journal article. I wrote this. You'd think that would make it okay to copy, but to my dismay, I discovered I gave away my rights to the publisher. So even I can't copy this. Copying is not part of Section 110 of the copyright law, but it is okay if it's fair use. So here are the things I'd like to talk about. What is copyright? Some axioms. Who owns the copyright? The copyright owner's exclusive rights. What's not subject to copyright? Classroom and online use, fair use, artificial intelligence, and some conclusion and discussion questions. So what is copyright? Copyright law protects the authors of original works from unauthorized copying. It's not limited to books. The work must be original, have some measure of creativity, and exist in fixed, tangible form. The creativity is important. So, for example, a list of items to pick up in the store, a shopping list, is probably not pretty creative. On the other hand, a list of ingredients in a recipe might be creative. They must exist in fixed, tangible form. So the verbal part of this presentation, as I'm sure you can tell, I'm not reading from a speech, so the verbal part does not exist in fixed, tangible form. Copyright protects creative expression, but not ideas and facts. Copyright balances the right of the author versus the right of the public to make use of the author's work. Copyright is different than trademark. Trademark protects the reputation of a business by discouraging others from using a similar name or a logo. The Coca-Cola soda logo example is a very famous logo, and someone who copies that, that's the subject of trademark law more than copyright. So here are some axioms. Just because you don't get caught doesn't make it legal. Much stuff on the internet is not okay to copy. There's certainly fun stuff on YouTube. Much of it is not there legally. The owner of the copyright may or may not care, but much of it is not there legally, and just because it's on the internet doesn't make it okay to copy. Citing the source does not make it okay to copy. Citing the source may keep you out of plagiarism issues, but that's sort of separate from copyright issues. Just because you're a teacher does not give you automatic fair use. The law is not absolute, and the law is ambiguous. And I am not a lawyer. This is not legal advice. Who owns the copyright? The creator, as soon as the work is created and tangibly fixed. No action is required, such as the copyright symbol. I did put the copyright symbol in the first slide just to reinforce the copyright idea, but that's not required. The lack of a copyright symbol doesn't change the copyright issue, and you don't need to file it with the government. For works after 1977, copyright rights last for the lifetime of the author plus 70 years. That's a long time. There are other rules for works prior to 1977, and each year some copyright rights expire. And on January 1, people are just sort of sitting for the clock to expire, and the clock to hit January 1, and then works enter into the public domain. Physical ownership does not give you copyright. I may have bought a book or a video legally. That does not give me copyright rights. And for teachers, who owns the teacher's creative work? The teacher or the school? It depends on the school's policy. I am not a music expert, and I'm not going to talk too much about music, but in music, who owns the copyright? It's the writer and lyricist or their employer, but not the performer. And for a live performance, the venue is supposed to pay a license fee to get the license. For fun, I sometimes ask at venues about this, and I often get a blank stare, or an answer such as, nothing's going to happen. But they're taking a risk there. Someone is supposed to pay a license fee. Here are the 5 copyright owners' exclusive rights. It's the copyright owner's right to make copies, to make derivative works, that's works that derive from the original work. This is not derivative as in a math context. Distribute copies, perform publicly, and display publicly. What is not subject to copyright? Ideas are not subject to copyright, but creative expression of ideas are subject. So an idea, for example, is boy meets girl, boy has a fight with girl, boy and girl make up. Nobody owns that idea. But there are many, many creative ways to express that idea. It's the creative expression of those ideas that are subject to copyright. Facts are not subject to copyright. Nobody owns, in 1492, Columbus discovered America. Nobody owns that fact. In math, theorems, proofs, examples, and tables are considered facts and are not subject to copyright. Nobody owns 1 + 1 = 2. Nobody owns the proof of the quadratic formula. And a word problem, as creative as you think it may be, is still considered a fact and is not subject to copyright. In math, there are generally only a limited number of ways to express most mathematical concepts, and that's another reason where creativity is limited in mathematics, and there are some legal theories supporting that. When something is subject to copyright, you can ask for permission. The owner may grant it, and sometimes the owner grants this in public arenas. You can pay for permission, such as a license, and here's one common place to do that. In a classroom, in a nonprofit classroom, so in a state college or university, there's a particular section of the copyright law. In a face-to-face classroom, teachers and students may perform or display copyright work. But remember, there's 5 exclusive rights. Those are only 2 of the 5. You must have a legal copy, which includes legally borrowing a copy, say from the library. And as an example, if you have a legal copy of the movie Stand and Deliver, you can show that in class. And remember, the key word here is nonprofit. If you're in a for-profit classroom, the rules don't apply, and this has to be face-to-face. For a nonprofit online classroom, it's a different section of the law. It's the same perform or display, but now it's only limited to the amounts which can be done in a live classroom. So if a live classroom is an hour, you can't show a 3-hour movie. And there are technological constraints on this, and this is why an online class does not stay online indefinitely. The very important section of fair use. Fair use of a copyright work in teaching is not copyright infringement. This applies to all 5 exclusive rights. To determine fair use, the factors to be considered include, but are not limited to, these 4 factors. The purpose and character of the use, including commercial or nonprofit, educational, and transformative. The nature of the copyright work, whether it's factual or creative. The amount and substantiality of the portion used. The effect on the potential market. Is there an economic loss to the owner? So a fair use requires an individual assessment of all 4 factors. No one factor outweighs the other. You have to consider all 4. And then the particular circumstances of this goes to court or decided by a court. These are the 4 factors of fair use. So a little more on fair use. Commercial use is usually not fair use. However, one way to sometimes get around this is that transformative use, which adds significant value by modifying the original, such as parody or a different purpose, is likely to be fair use, even if it's commercial use. And that goes back to that R-rated version of Pretty Woman. Factual work is more likely to be fair than creative fiction. The smaller the amount used, the more likely it will be considered fair. So again, in those 2 sound clips, I used as small a portion as I thought I needed to make my point. I didn't use the whole amount of the songs. If an owner charges a fee, then there's substantial or potential economic harm from the copyright, which is not likely to be fair. But if there's no commercial value, it may be fair. Copying and distributing always require fair use analysis. There are so-called guidelines by vested interest groups. You may see things like the 10% rule, but these concepts are not mentioned in the law. They're not neutral interpretations of the law. They do not carry any force of the law. There's a Georgia State case where the judge thought a 10% criteria was too low, but you can't generalize this ruling. And experts say the 10% guideline is fiction. There's a famous monkey case. A photographer set up a camera, a monkey took a selfie, and this is an example of it. Who owns the copyright to that? The court ruling was non-human actors are not entitled to copyright protection. The monkey did not own the selfie, and it's in the public domain. Which gets us to artificial intelligence. Certainly AI is quite new. The Copyright Office is studying this. The subject's in flux. Probably the AI robot owns no copyright because it's non-human. If the human provides original creative input to the robot, the human may own the copyright to the human's aspect of the work. But you should not be using someone else's copyrighted work. There is a lot of AI digital work where the original work belongs to someone else. The robot does not own the digital work, but if you're using someone else's copyrighted work, I'm not sure that the robot changing this changes the fact that you've used someone else's work, but the subject is certainly in flux. So in conclusion, here's a little framework to think about when you're considering copying some work. Is the work protected by copyright? If so, is there a license covering my use? If not, is there a specific exemption in the law, such as Section 110? If not, is my use covered by fair use? And if not, do I need the copyright owner's permission? So here are a few discussion questions. Can I create and sell a solutions manual to a textbook? No, this is what's called a derivative work. This is a work that derives from the original. The owner could have written a solutions textbook even if they didn't. And this would likely fail fair use because the copyright owner would or could suffer economic harm. May I copy a published math test as a study guide, and especially because I previously said math problems are not copyrightable, so can I just copy and publish a math test? No, and this has been resolved because the choice of the problems, including research on their reliability, has been deemed creative. I'm not adding any creative effort by just copying. This fails fair use. The Education Testing Service may license in-class use, but specifically prohibits then using the use as homework. Give some examples of transformative use in math. So here's an example that I've used. This is Homer Simpson with some math equations on the board. What's the original use? Entertainment and humor. What's the transformative use? Explaining what this equation represents. This is a counterexample to Fermat's last theorem. The transformative use is math, and I think that's so different from the original use. I think that's permissible transformative use. Here's another example. Here's some data. The data goes from about 15 to 49. What's your forecast of the next number? How likely is the next number to be 73? This is my original problem. Is it copyrightable? Here's what the data is. This is Barry Bonds' home run statistics. And sure enough, he hit 73 in 2001. Here's a picture of Barry Bonds in his early years. Here's a picture of him in his later years. Certainly, I don't own the rights to these pictures, but what's the original use of the pictures? To show his steroid use. What's my transformative use? To talk about statistics and outliers and probability. I think this is permissible use. Here's a photo of Taylor Smith. Here is an equation. What's the original use? I guess to show how pretty she is. What's the transformative use? If you're a math person, you know what the relationship is between Taylor and the equation. If you're not a math person, I'm not going to give it away. Can I create a course pack of portions of selected readings? This seems awfully dangerous and likely to fail fair use. Georgia State ruling of several publishers versus Georgia State did permit this, but the ruling is based on the particular circumstances where many of the readings were included in small enough portions, although some readings were not included in small enough portions and were disallowed. Really, if you're going to do this, get permission by a license. Here are my references. This is a complicated, but I think interesting topic of copyright. So there are many things that teachers can legally do, but there are some things you can't do.